Hello, welcome everyone. My name is Enrique, and I am one of the panelists that collaborate here at the Autism Risk Coalition. Today, we're very, very fortunate to have Michael Allen. Michael, thank you so much for joining us today.
My pleasure.
So, Michael Allen is a partner at Relman Colfax in Washington D.C. Michael joined the firm in 2006. His civil rights litigation practice focuses on the Fair Housing Act, the Americans with Disabilities Act, and related civil rights laws with an emphasis on dismantling barriers to integration on the basis of disability and race. Over the past 15 years, Michael has led the firm's disability rights practice, and it has litigated dozens of housing discrimination cases. Among the most prominent is the Independent Living Center versus City of Los Angeles, which challenged the city's failure to ensure that its 70,000 unit affordable housing program complied with federal and state accessibility requirements. And it settled in 2016, and it remains one of the largest settlements of its kind anywhere in the U.S. Michael has also used litigation and administrative complaints to challenge policies to perpetuate racial and ethnic segregation, and he's really a quite knowledgeable attorney in this practice. Prior to joining the firm, Michael was a senior staff attorney at the Baseline Center for Mental Health Law, where he focused on civil rights policy development and litigation involving people with psychiatric disabilities. So in this live webinar, Michael will provide an overview of the mechanisms to protect individuals with autism and their families against housing discrimination, and to promote social integration on the basis of disability and race, among other topics. As you know, and as many of our people in our audience are aware, the CDC actually came out yesterday providing an update on the prevalence of autism cases on 1 in 44 children in the U.S. that are currently being diagnosed with autism spectrum disorder. So this is a super, super important and relevant topic for our audience. So Michael, we're super excited to have you on, and thank you so much for doing this today.
Yeah, my pleasure. I do have a presentation, which will be, Enrique will bring up at the appropriate time. And I think we're advanced just a little further than we want to be, Enrique. So I'm going to see if I can control the slideshow. Bear with me just a moment. I don't seem to have control of the slides. I apologize.
Let's see. Are you able to control them now?
I think maybe. Let me just bear with me just a moment. I apologize. We'll start from the beginning. I do not.
Okay. So perhaps we could reshare the screen one more time to see if we can pull them up.
Sure. I'm sorry, it's telling me that I have no slides.
Oh, interesting.
Let me just try one more thing.
Sure. There you go. We can see the slides. Yes.
Okay, terrific. And I'm sorry for the little hiccup there.
Oh, thank you. Thank you.
So let me just begin by saying that, in addition to having worked as a civil rights lawyer at a private firm for 15 years and at the Baseline Center for Mental Health Law for 11 years before that, I started my life as a legal aid lawyer. So I was very focused on the needs of individuals and families with low incomes and people who were with and without disabilities, struggling to keep stable housing. I mean, the importance of protecting people with disabilities and all people from housing discrimination, I think, really is focused on the fact that we all need stable housing. We all need a place that is, where we can feel safe. It's a haven from the outside world. It's a place where our dreams are born and, where we can carry them out. I want to take you through a presentation that talks about the history of discrimination on the basis of disability in all areas, but particularly in the area of where people with disabilities live in this country. And it is literally true that for the better part of a century, the official policy of the United States was really to segregate people with disabilities from what was thought of as normal society. Tim Cook, who's the author of a famous law review article, was himself a person with a disability and helped to, in my mind, to really frame for me the kind of work I've been doing over the last 30-some years. Cook's article gets to the very basis of why people with disabilities have often been thought of as not part of the American mainstream. He said, in the view of at least one agency, state agency, and I believe this was Texas, official state policy was that people with disabilities were basically a defect that wounds our citizenry 1,000 times more than any plague. So the idea that disability somehow others us is an important concept here and has really infused policy, housing policy, social services policy, and lots of other private agency and public agency policy in this country for far too long. And Cook goes on to note that people with disabilities, often ended up living in large institutions and hospitals because that was thought to be the charitable thing to do, that somehow people with disabilities, given that they were less, that under those circumstances, they had to live in places that were best suited to make each person useful and happy. This is why we ended up with institutions in this country. So 100 years ago, when we talked about housing policy for people with disabilities of all kinds, including psychiatric and physical disabilities, many folks experienced, large state institutions such as the one on the screen as housing for people with disabilities. We've moved forward somewhat over the years, but we still have circumstances where people with various kinds of disabilities, physical and mental disabilities, end up segregated in other kinds of institutions that might be called nursing homes or assisted living. People end up, in the variation in New York for many years was when large institutions closed, private landlords started putting up what they called adult homes, which were little more than institutions in the community. And far too often, people with disabilities of all kinds are separated from their families and live in other smaller institutional settings in the community, sometimes labeled group homes. I think the point about that history, as brief as I made it, is that the idea of full integration into the community for people with disabilities in their family units and outside their family units is a surprisingly recent vintage. A case got to the Supreme Court in 1985 that tested the question of whether or not people with intellectual and developmental disabilities would be permitted to live in the community as opposed to institutional settings. And in the city of Cleburne, the Cleburne Living Center proposed to have a group home with 13 men and women with intellectual and developmental disabilities. But the town said, basically, we don't want you here. We don't want your kind. And they said, you have to go through a special use permit in order to get our permission to be here. This is the classic kind of second-class citizenship that has marked housing policy for people with disabilities for literally for decades. In 1985, there was no federal law on the books that would have protected people with disabilities against this kind of discrimination by the city of Cleburne. And so the claims were brought under the Constitution, the U.S. Constitution, and specifically the 14th Amendment's Due Process Clause. 1985, now this is 3 years before the Fair Housing Act included protections for people with disabilities, and it is 5 years before the Americans with Disabilities Act passed Congress. Without going into a whole lot of details, the Supreme Court looked at what the city of Cleburne had done, and the majority in this case said there's no there's not even a rational explanation for why the town would have turned down this group home in the community. And they said basically, send it back and do it the right way. The Constitution's equal protection and due process clauses forbid this kind of differential treatment of people with disabilities. The more important thing here, though, when you think about the disability rights movement generally and in the context of housing, is to take a look at Justice Marshall's concurring opinion in this case. The majority of the court, through Justice White, spoke for itself and struck down the actions of the city of Cleburne. But Justice Marshall, who was the first Black justice on the Supreme Court, wanted to take this a step further. And he said, what we see here really is, the product of social Darwinism. He says, for so long we dismissed and we othered people with disabilities. And it led to a place where many experts considered people with mental disabilities as menaces to society. Given that mindset, he said, there was a regime of state-mandated segregation and degradation that soon emerged that in its virulence and bigotry rivaled or indeed paralleled the worst excesses of Jim Crow. So Justice Marshall, who had lived race discrimination and fought race discrimination throughout his professional career, said this is nothing more than bigotry of the lowest kind. And we need to understand that if we're going to get to the underlying narrow thinking, and if we're going to get to a place where people with disabilities, like others in this country, have an opportunity to live in housing of their choice. A few years later, 3 years later, Congress finally passed the Fair Housing Amendments Act. Now, the Fair Housing Act has been around since Martin Luther King's assassination. In fact, the assassination is the event that moved the Fair Housing Act, the original Fair Housing Act in 1968, to final passage. And that law prohibited discrimination and continues to prohibit discrimination on the basis of race, color, religion, and national origin. But in 1988, Congress said, those four protected classes deserve protection against discrimination, but so do people with disabilities. Unfortunately, Congress in 1988 used the word handicapped, which I think is an archaic term and a not entirely respectful term. But to this day, the Fair Housing Act speaks about protection from discrimination on the basis of handicap. But Congress said, starting in 1988, this new law prohibits the use of stereotypes and prejudice to deny people, the right to live in housing where they want to live. The right to be free from that discrimination is essential to the goal of independent living. In other words, Congress was saying, as a national policy here, we're going to put in the rearview mirror discrimination of the kind that separated people with disabilities from people who don't have disabilities. And 2 years later, Congress passed the Americans with Disabilities Act, which is important particularly in the area of housing and services that are provided by state and local governments. So the Fair Housing Act prohibits discrimination in the private market as well as by state and local governments, but the Americans with Disabilities Act focuses specifically on those state and local government agencies that provide support for people with disabilities and that provide other kinds of community services. As I said, the purpose of the Fair Housing Act was really to remove those barriers that people with disabilities had faced for so long, the barriers that kept them from being equal members of society. And in a passage of the Fair Housing Act legislative report that has found its way into literally dozens of federal court decisions over the years, Congress said, this law is a clear pronouncement of a national commitment to end the unnecessary exclusion of people with handicaps from the American mainstream. So I've spoken largely in the context of broad policy now. I want to say a few things before I talk to you about cases relevant to this audience, or maybe of interest to this audience. I want to tell you a little bit about the structure of the Fair Housing Act and of the ADA. Each of these laws says that it is illegal to treat people with disabilities differently, less well and people who do not have disabilities, so that the entire housing market, whether it's for sale, whether it's condominiums, whether it's rentals, whether it's the ways that lenders or insurance companies treat housing and people who want to buy housing, whether it's homeowners associations, whether it's newspapers, all of these entities, anybody who can affect the availability of housing is prohibited from discriminating on the basis of disability. There's another important part of the Fair Housing Act and of the ADA that says, in addition to not discriminating, in the context of disability, all of these folks, realtors and landlords and management companies and homeowners associations and banks, anybody who can affect the availability of housing for people with disabilities also has another obligation, and that's called the obligation to provide reasonable accommodations. And it's a bit of an abstract term, and I'm going to talk to you about it in the context of a case or two momentarily. But I want to leave you with this thought before I move on, and that is the concept of reasonable accommodation means that if you, as a person with a disability, or if you have a person with a disability in your family or household that needs a change in the way that things have always been done, rules, policies, practices, you're entitled to ask for an exception. And in most cases, you're entitled to get that change or adjustment or even a waiver of a rule if that change or adjustment or waiver is necessary because of the disability. So again, I'm going to try to apply this in a couple of cases that I'm going to talk to you about momentarily. I've featured now a couple of cases, a couple of 3, 4 cases that my firm has handled in the context of broadening the rights of people with disabilities to live where they want to in the community. The first case up on your screen now, the Rodriguez case, went all the way to the Court of Appeals for the Second Circuit. And just imagine this as the court that is right below the Supreme Court. So we've gone through the federal trial court. We're now at the federal appeals court. The Second Circuit covers New York, Connecticut, and Vermont. And so since our appeal came from New York, from the state of New York, we ended up in the Second Circuit. In this particular case, AR, an adolescent girl, young woman, was diagnosed with epilepsy and had a pervasive developmental disorder on the autism spectrum. On account of those two things, she also had an individualized education plan at her local school. The family had lived in a rental house in upstate New York for a couple of years. Once the agent learned that AR had these disabilities, she told the family that it had to vacate the rental unit immediately in the middle of the school year. It was actually in the middle of winter. I'm not sure exactly what was in the realtor's mind, but as she later expressed it in a deposition, she thought that a child with these kinds of disabilities should live closer to a hospital or some sort of institutional setting in the event that, in the event that her disability should flare in any way. It is, in my mind, the very kind of stereotypes and bigotry that Congress rejected when it passed the Fair Housing Amendments in 1988. But as a practical matter, this realtor was controlling this particular family's ability to stay in its housing. It took a while to litigate these claims up through the Court of Appeals, but eventually the Court of Appeals made 2 important findings in this case. Important not only for AR and her family, but also for everybody else in the country who's looking for guidance about why this is illegal. The court said that AR and her family could prove her disability even with non-medical testimony. This means that a family doesn't need to go deeply into debt just to establish in the first instance that the person who needs protection from discrimination, in fact, has a disability. This is an important breakthrough. It's an important statement by this court that parents and teachers and lay people, as well as medical professionals, have the ability to speak and to prove the disability of somebody facing discrimination. The second thing that the court said is that it thinks that obtaining housing or even keeping housing is a major life activity. The definition of disability under the Fair Housing Act and the ADA is very broad. The Supreme Court has told us as many as 70 million people in the country will benefit from disability protection under those two laws, because the law is meant to cover anybody who currently has a disability, or has a history of a disability, or even if they don't have a disability, if they're treated by the discriminator in a way where the discriminator assumes they have a disability and acts on that basis, all of those things are illegal. So the court here said the definition of disability focuses on somebody's ability to do major life activities. If finding and keeping housing is a major life activity, and somebody is deprived of that on the basis of disability, that's enough to prove liability under the Fair Housing Act. After the court's decision, there's a confidential settlement, the terms of which I can't share. I can simply say the family was delighted to have contributed to a positive outcome, not only for itself, but for other people who will be guided by the Second Circuit's decision. A couple of years later, we represented the Kelm family in a matter that was litigated in the federal court in the Northern District of Florida. The basic facts of the complaint lay out what happened in this case. The Kelm's child, age 9, had autism and epilepsy, and therefore is considered a person with a disability under the Fair Housing Act. That child was often overwhelmed by new environments or overstimulation. And in the family's home in Tennessee, the family had established a sensory room, a place where they could control the levels of noise and activity and other visual stimuli to keep the child from exhibiting any dangerous or self-destructive behaviors. They proposed to do the same thing, to establish a sensory room in their vacation home in Florida. And the homeowners association told them that they could not do so. And if they didn't cease construction and return, the space in their third floor of their house to its prior condition, they would face a lawsuit. We called it out for the kind of discrimination that it is. The family owned the home, was not expanding the footprint of the home, and the homeowners association essentially stepped over the line in a way that made it impossible to provide QK the kind of safe space that he needed in the family's vacation home. The matter also settled before it got to trial. And again, without being able to reveal the terms to you, I'll indicate that we essentially got the family what it was seeking, which is conditions in which they and their son could live and live in peace. We also handled a matter a couple of years ago against the Dallas Housing Authority. And this is important because the Dallas Housing Authority is one of those local agencies that will have obligations both under the Fair Housing Act and under the ADA. The Housing Authority, after years of study, decided that it would take some of the housing subsidies that it controlled, which were known as vouchers, sometimes known as Section 8 vouchers, and make those available to families who wanted to buy homes and establish small group homes for people with intellectual and developmental disabilities in the Dallas area. So parents of adults with IDD thought that these project-based vouchers would benefit their children and others, essentially allowing them to move out of institutional settings and what are sometimes known as training schools for people with intellectual and developmental disabilities into housing that looks like where you and I live in the community. The Housing Authority canceled the program without explanation. It decided that it simply wasn't going to serve families in this way and wasn't going to allow people to move out of institutional settings and into more normalized community settings. The matter settled after a fair amount of litigation, with the Housing Authority agreeing to make those vouchers available after all, and to work closely with our client, which was the Community for Permanent Supportive Housing, in order to make sure that people with disabilities, their families, service agencies, and others in the Dallas-Fort Worth area would have an opportunity to use these housing subsidies to allow people with disabilities to live in small single-family homes in the community. One more case, and then I'm going to move on toward closing remarks, and happy to answer questions. As I told Enrique, I think it's important, after sharing some of this information, that I do the best I can to answer questions from anybody in the audience, because something that you learned today, you ought to be able to put to use tomorrow. And rather than just dwelling for too long on my slides, these are just ways to introduce concepts that the Fair Housing Act and the ADA can offer substantial protection against all kinds of discrimination by all kinds of entities. Let me talk a little bit about Gilead, and then I'll make the turn toward home. Gilead Community Services, a group in central Connecticut that's been around for about 45 years, wants to serve people with mental illnesses, but to do so in the community and outside of hospital or institutional settings. So in 2015, it bought a group home in the town of Cromwell, Connecticut, fairly well-to-do town. But the town officials decided, responding to neighbors who didn't want those kinds of people in their town, town officials decided that they would do everything that they could to stop the group home. Eventually, 2 of the 6 men who were in line to get out of institutional settings moved into the group home, but only for a short period of time, because effectively, through removing tax benefits, challenging their funding, and challenging them in court, the town effectively shut the group home down. We sued under the Fair Housing Act and the ADA, saying that this is a form of discrimination prohibited under those laws. And in October 2019, the court basically rejected the town's attempt to get rid of the case. It said, "We haven't heard all of the evidence. This matter should go to a trial." And that trial, in fact, happened just a little bit ago. I'll tell you about it in just a moment. As part of that summary judgment decision in 2019, Judge Bolden, in this case, went back to that City of Cleburne case, and he said, you know, they were right then, and that's the rule that I'm going to apply now. We should not be in a place where government officials can take this kind of action based on prejudice, or the prejudice that citizens of the town may hold against them. My partners and colleagues had a 2-week jury trial, which ended on October the 15th of this year, in front of a fairly well-to-do suburban jury that heard all of the evidence and unanimously held that the town was liable on all of the Fair Housing Act and ADA claims that we made. Paid Gilead back, rather, the money that it had lost on the purchase and eventual sale of the home, and wanted to send a message to towns like Cromwell by imposing a $5 million punitive damages verdict, saying that the town's behavior was so outrageous that it deserved to be punished well above just the monetary loss that Gilead suffered. And it really is meant as a warning to all other towns that discrimination on the basis of disability, particularly when it has been illegal for more than 30 years, just cannot stand. For anybody who's interested, Enrique should feel free to share the slides for anybody who wants them. There's a link here that suggests or that points to kind of the rest of the story about the Gilead case. I will say that it garnered lots of negative press, and so in addition to everything else, the town of Cromwell, now has some reputational damage to undo. I'm going to turn toward the end now. I've just got a couple more slides, a few more slides to go. I showed you 4 cases. Some of them involved tenants, some of them involved homeowners, some of them involved zoning. The point is, across the spectrum, people with disabilities, whether they're homeowners or tenants, are likely to face continuing discrimination. In the rental context, people with disabilities often get more questions about, what is your disability? Or they may not get their questions answered about available apartments. There's resistance of all kinds, even when people ask for the reasonable accommodations that I mentioned before. The reasonable accommodation piece of the Fair Housing Act and of the ADA is important to understand because it isn't exactly a go-free card, but this is available only for people with disabilities. It's illegal to refuse to change your rules, policies, or practices when that accommodation may be necessary to help somebody with a disability to get the equal opportunity that they need to be in housing. The simplest examples that I can give you around disability is somebody who's blind or has a mental illness may not be able to read a rental application and may need help, from the management in terms of doing that, or may need help filling out an application. Somebody who needs a service or emotional support animal, companion animal, may be entitled to have that animal even if the general rule is that there are no pets in the building. Somebody who has been in the hospital for some reason and may need an extension on paying rent should be able to get that waiver or extension on the basis of that disability. Somebody who needs an accessible and close parking spot because of a mobility impairment or a physical impairment should be able to get that. There are other slides that I'm going to whiz through here. I want to let you know that at the very end, or toward the very end, my former employer, the Bazelon Center for Mental Health Law, has some of the most robust resources available in terms of housing and disability, and that in sort of one place can provide robust information about how to exercise your rights, has sample request letters, talks about some of the cases that I've mentioned before and provides their citations. It's accessible both to a lay audience, but I think also to an audience that speaks with respect to the law. So I'm going to finish now, and I'm going to pitch back to Enrique and ask him if he would guide us in the next part of our conversation.
Yes, thanks a lot, Michael. I mean, that's a great overview of these laws and a brief history on those. We definitely are going to be sharing the slides that Michael just presented with our audience after the presentation today. So I do have a lot of questions, Michael. Some of them are coming from our audience, and some of them, unfortunately, are personal because everything here, everything we do is kind of with intent of helping others, and unfortunately, there's people like me and others in our audience that are experiencing this right now. So what I would like to ask you is, everything you have described is it's it's the basis for the application of these laws, right? I think I would like to get into the practicality of what you described, if you don't mind. So for example, regular families, when they are approached by HOAs or cities or landlords, they oftentimes get communication from their attorneys, like right off the bat, right? And making these demands for something to change because of X, Y, and Z in the way that you described it. So I guess one of the first things that I would like to ask you is, for anyone that is watching that is involved in a case like this that you're not expecting, you all of a sudden get a letter on your door, making these claims about something that you're supposedly doing wrong. What would be the best way to move forward, according to in your experience?
Well, I would say this: every case is going to be somewhat different. There are networks of disability rights specialists in every state around the country. There are firms like mine, although not many of them, where people have a part of their practice that focuses on disability rights and enforcement of those rights. The Department of Housing and Urban Development, the federal agency, sometimes known as HUD, has a complaint process, which is meant to be fairly straightforward and something that you can navigate without a lawyer. The Department of Justice has a civil rights division and a housing section that looks at systemic problems of discrimination, particularly involving things like lending or zoning discrimination. And I can certainly, the Bazelon Center booklet that I mentioned right at the end of my presentation has links for all of those. My firm has a national practice, and we get emails and telephone calls from people every week, sort of asking, whether there's some assistance that we can provide. So there are lots of resources out there, and I'd be happy to work with Enrique and with the coalition more generally to think about how to have all those resources available to your members. Also happy just to take questions from people. My email is in the materials. Happy to recite it again at some point, or maybe somebody could put it up in the chat. Enrique, if you could put it in the chat. But I do think the important thing to do is not to feel bullied. I've spent the 36 years that I've been out of law school trying to fight bullies, people who are trying to throw their weight around, whether it's a homeowners association or a lender or their lawyers, and to say, wait a minute here, we're going to do this the right way, we're going to do this the respectful way. But if connecting you with a lawyer on the local level or perhaps somebody in my firm, if we're available to do something, I'd be happy to take inquiries and to try to guide people to the right place.
Yeah, absolutely. We'll be definitely showing your contact information with the audience. So you were, during your presentation, you were alluding to the people with disabilities and their caregivers, right? So I guess a question that I have is, does these laws that you mentioned that are federal laws, do they apply equally to both the person with the disability and also to the caregivers? So in other words, if there's got to be like a reasonable accommodation or modification for the caregiver, because at the end of the day, they are the ones that that are kind of on the trenches every day. Does this also apply to like the entire family or even to external caregivers more generally?
Great question. So both laws, the Fair Housing Act and the ADA, in their definitions of disability or of handicap, they say it includes the person, him or herself, but it also includes people who are associated with that person. So that's certainly broad enough to include family members. So whether you're providing care and support, love and affection for your child or for your parent with a disability, you're protected. There's no magic about having to be the head of household. So anybody in the household who's providing that kind of support is certainly covered. The for-profit and nonprofit entities that care for people with disabilities. So in the Gilead case, Gilead was a nonprofit social services mental health agency in Connecticut. It's entitled to complain about discrimination because it is harmed by the town's discrimination just as its residents are harmed. So Congress meant to provide broad protection. And sometimes people with disabilities, need the help of an agent or, friend or caregiver or family member in order to articulate these rights. And so Congress wanted to make it, as broad as possible. Congress wanted to stop the discrimination. It wasn't going to quibble about, who had to complain.
Yeah. So I'm getting some questions, which I think you have addressed, but I'm just going to kind of reiterate that, for the sake of the conversation. So some people are asking if you accept cases in other states. Obviously, your firm is based in Washington. You have presented cases in other states. So I'm assuming the answer is yes. So I mean, there are some people that are actually seeking right now for someone that is able to represent their cases. There's also some others that are, asking about your affiliation or potential partnership with insurance companies, right? With legal insurance. If that's something that is a possibility in your specific, case with your firm and their in their situation. What's your stance on that?
Let me address both those questions if I could. So our firm is small by law firm standards. We have 24 lawyers. We are based in Washington, D.C., and our lawyers, are members of the bar in Washington, D.C., and in some other states. When we enforce the federal civil rights laws, and it becomes necessary to do so in a state that's distant from us, and I would guess now we probably have cases going on in 20 or 25 states, we affiliate with a local attorney who then vouches for us. There's a whole process by which we can appear in cases, even if we're not a member of the bar in that particular state, under the supervision of somebody who is. So there's no limit on where we can go. And in fact, not just in the federal court system, but also in the state court system, those same kinds of rules apply. So I'm currently involved in a state court case in California, where the lawyers who brought the case thought that I had particular expertise in an accessibility issue. And so the court there has given me permission to come into that case, even though I'm not a member of the California bar. The issue about expenses, and I guess or I should say fees and expenses, and every case is going to be somewhat different here. But let me say the following, that, unlike a nonprofit, unlike a legal aid organization or a disability rights organization, nonprofit in the state, which serves people for free, my firm typically has to charge people for the work that we do. The wonderful thing, though, is that the civil rights laws, the two I've talked about and many others, have something called a fee shifting provision in them. And usually in the United States, if you bring a lawsuit, you pay your own lawyer, and there's no way you're ever going to get that money back. The civil rights laws say that when you have to sue to enforce your rights, and this could happen even if it's just in a HUD administrative complaint or if it's in state or federal court, if you are a prevailing party, if you get some chunk of what you've asked for in having to file a complaint or a lawsuit, the other side can be required to pay your attorney's fees, so long as they're reasonable. You can't run up an unreasonable bill and ask the bad guys to pay. But the wonderful thing, in each of the cases that I mentioned to you today that my firm has handled, we have either negotiated for the other side to pay our fees, or we filed what's known as a fee petition with the court, and then the judge sorts out what we're entitled to get. So as a practical matter, we can take on some cases, not all cases, but many cases we can take on without asking people to pay anything out of pocket. Now, we can't take on every case. We're 24 lawyers. And there are often times where it really makes sense to have somebody who knows a lot more about the local conditions to do that advocacy for you. But all of those lawyers are entitled to fee shifting as well. If they have to sue to enforce your rights against discrimination in housing or under the ADA, and you don't even have to win it all, but if you win, some piece of what you're asking for, you're going to be a prevailing party, and you're going to be entitled to ask, the discriminator to pay, a portion or all of your fees.
You in the cases you mentioned, Michael, someone may argue that, like, for example, in the case of I believe there was a case in Florida where they were kind of changing a room to make it a sensory environment and those kinds of things. When you were getting these complaints from the HOAs or the city or the landlord or someone else, it seems like it's not always a clear-cut case, right? So there's got to be like some there may be some responsibility on behalf of the family that has the disability that we all, including my own family, we live almost like in a life-saving mode, like day in and day out. And frankly, we sometimes tend to kind of resource on things that may be a little unorthodox, right? That on the eyes of the rest of the world, what we do or the things that we have access to or look for may not be necessarily like the norm, because we just simply don't live quote unquote normal lives, right? So I guess what I would like to ask you is for some parameters. So our audience can think about some situations where like in spite of the difficulty, or in spite of the challenges, or in spite of the mistakes that we could have made, we are still kind of protected by these provisions, right? So I guess, to what extent do the things that we do, or the mistakes that a certain family might have made, would be subject to like further fights from the let's say the other parts attorneys to continuing this bullying, if that makes sense. So if you could kind of provide some ideas for things that where our cases would be protected, as opposed to us feeling like we did something wrong and therefore we are not entitled to protection, if you will.
Sure. So I'll do my best. I'll say a couple of things. One, these common interest communities, these homeowners associations, condominium co-op associations, often feel like, they got their rules, like on the stone tablets that Moses brought down from the mountain. They think that these are the most important things. They think this is all that really counts. And I can't tell you how many homeowners associations or condo associations I've talked to that said, we don't have to follow the federal law. We've got our own bylaws. And the answer is that's absolutely wrong. If you thought about it as a pyramid, the federal law is at the very top. And so it will overcome, it will, what word do I want to use here? It will trump all other laws, and whether they're private or public. So, a state or locality that has a discriminatory law is going to have to give way to the Federal Fair Housing Act that says the Federal Fair Housing Act is supreme. It's a federal law. And in the same way, homeowners associations, condo associations have to comply with the state and the local and the federal law. And if the federal law tells them that their bylaw is discriminatory, then it can't be enforced. So that's just, bottom line. Secondly, I think I've probably said this dozens of times in presentations too, and I hope not to offend anybody on this call, but the people who tend to be, like the leaders or the presidents of these common interest associations are the people who didn't get elected class president in their high school. They exercise, or they think they can exercise, this power over people, without thought, without reason, simply sort of to exercise power. And that kind of bullying is something that really offends me on behalf of my clients. But so let's just assume, that all of us are going to, and whether you think about messing up or, technically violating a rule, I think we're all subject to doing that. But when it grows out of a disability, like if you have a child, who gets agitated and acts out, or if you have a child who can't go out in your backyard if the fence in the backyard is only 3 feet high, which is what the homeowners association says it needs to be, but if that was 8 feet high, she could be completely safe and have all the outdoor experiences that she needs. Or a case we had a few years ago, family wanted to be able to put a trampoline in the backyard, trampoline with a sort of net around it so that the child could go out in the back and just get exercise and work out various sorts of, tics and aggressions and things. So you're entitled to ask for an accommodation, a change. That accommodation, as the law says, can only be a reasonable one. It's something that can't have, a huge impact on the community. You can't say, basically, I want to build a hotel in a residential community. You can't say, I want you to do my grocery shopping for me so I don't have to do it. You don't want, you can't ask the homeowners association to do something that it doesn't normally do. But where the request is basically to be left alone, give us some time to deal with our child's behavior. Let us work through whether it is with, health professionals or exercise professionals or whatever. What can we do to, remain in this community and not feel like we have to walk on eggshells or, look over our shoulder every 5 minutes? The requests, or not the requests, but the demands that you get from an association or association's lawyers, the threatening letter that talks about fines and special assessments and loss of rights and all that sort of thing. Often that can be dealt with just by not necessarily going straight to a lawsuit, but having a qualified lawyer or disability advocate help you push back against that. I mean, I've written dozens or perhaps hundreds of letters that say, perhaps you don't understand the deep hole that you're digging for yourself if I have to sue you under the Fair Housing Act. Here are the cases that talk about an accommodation. Let's have a reasonable conversation about this. And if the association writes back and says, we're not going to even talk to you about your accommodation, well, that by itself is a violation of the Fair Housing Act. So I guess what I'd say is live with the confidence that we can't all be, cookie cutter patterns of each other. And that if our family needs something on the basis of disability that seems a little bit out of the mainstream or even a lot out of the mainstream, I think the reasonable accommodation part of these laws says we have a right to ask and we have a right to make our best case for it. And it says that, the folks on the other side have to listen carefully. And if they're not going to give it to us, they're going to have a pretty good explanation. That doesn't come naturally to bullies, but I think it's one way, effectively to stand up and say, we don't want to take it anymore. You shouldn't, your challenges are significant enough dealing with kids on the spectrum. You shouldn't have to worry about losing your housing or losing your rights because of some narrow-minded, HOA president.
I couldn't agree more. I would just say that. I would just like to share to shift gears a little bit to talk about the city, right? So the city's involvement is also important for like the reason of the zoning. Sometimes the zoning officers are involved in these type of disputes. Sometimes the bylaws regarding, let's say, accessory apartment units, right? So these sometimes families have legally or illegally, probably, I don't know the case of the families that you have represented, but they may have these accommodations for caregivers, like in-home therapists and things and people like that. And sometimes like the zoning is a little difficult to navigate, right? Sometimes they allow for these types of accommodations for caregivers, but in this situation that you have described with HOAs or other participants, will cities also be required to comply with these reasonable accommodations, reasonable modifications? It sounds like by everything you're describing, all these provisions would also apply to cities officers. But could you comment on that?
Yeah, I would just say you're absolutely right there, and there are literally dozens of cases in which federal courts have said just that. It happens, in the question of, where group homes can be located. It comes up in the context of other kinds of affordable housing. There's a case, out of the state of Oregon where, a guy who had, quite frankly, had a hoarding problem, was going to get thrown out of his house because the health and safety people thought that he wasn't, sort of cleaning up his house and his yard effectively enough. And that went all the way to the Court of Appeals for the Ninth Circuit out in the West Coast. And the court said, yes, absolutely. I mean, of course you need to give these people, you need to give this guy some additional time. You need to give him a break because his disability has kept him from addressing these underlying problems. And, as a practical matter, asking for some additional time to do something or to do it in a slightly different way is not going to be what the courts call a fundamental alteration of the zoning law. And it's only those fundamental alterations, that go way beyond, kind of the modest adjustment that the guy in Portland, Oregon was asking for, that get turned down. Yes, everybody who can affect the availability of housing, including cities, have an obligation to engage in this accommodation process. And the courts have said over and over again, because the disability of each person who requests an accommodation is different, there's no like magic yes/no process. You need to get involved in what's known as the interactive process. And if the person asks for something, that accommodation that, in this case, say the city or the homeowners association think is too big a lift, well, the city or the homeowners association can't just say no to that. They have to come back with something that would, help to solve the problem that just wouldn't be such a big lift. And until they do that and do that, really in good faith and with goodwill, they're not off the hook. So yes, across the board, everybody that you could imagine, same rules about accommodation.
Yeah, it's the interaction, Michael, when you're involved in these situations, and like I said, unfortunately, I have personally been involved in these situations, is really, really heartbreaking and difficult to even understand as the person that is kind of going through this situation. And that point that you mentioned about the interactions is very cumbersome. I mean, for lack of a better term. So you get these letters from these different people, and then you want to have an interaction as a human being, being able to have like your explanation to what's going on, and there doesn't seem to have a conversation. Everything is done through the attorneys once the attorneys are involved. So I guess for my last question for you would be some best practices for our audience to interact with these different actors. I mean, when you're getting like these, feedback from a city officer saying, no, I cannot, I don't have the power to change the bylaw, which is a city bylaw, because there's got to be like some voting decision that needs to happen, or an HOA that says, no, I cannot do that because I need voting from the town or something like that. And therefore the situation is very difficult, and there's really not a straightforward back and forth between the families and these different actors. So what would be your recommendations as to how navigate these things? I mean, beyond looking at the obviously all the documentation that you have referenced, so just some best practices for these interactions that you were talking about.
Sure. So first of all, I suggested, starting with the mindset of, as long as what you're asking for is reasonable, whether somebody comes to you and alleges that you've violated something, or you're asking affirmatively for a change that, is, typically not a typical thing that would happen, just start off with the mindset you're probably entitled to it. Secondly, if you feel like you're being bullied, just know that this is happening all over the place. It's part of the playbook for the other side, because it's just much easier to say no to things than it is to engage meaningfully in this kind of conversation. We didn't talk at all about disability culture and stigma, but I think one of the biggest problems is that although literally 1 out of 5 people in this country may be protected by these disability rights laws, I think most people still are squeamish about disability. Maybe they understand the person who uses a wheelchair or the blind person who uses a white cane, but they don't understand other kinds of emotional and psychiatric disabilities. They don't understand autism. They're afraid. They've been conditioned to be afraid about it. So it's uncomfortable. It's an uncomfortable conversation. And it requires, unlike any other discrimination case, right? I said reasonable accommodation is only for disability. It requires getting really into the thick of things. And you can't say, this is our rule, it's always been our rule, and we're not going to change it. That violates the reasonable accommodation part of these 2 laws. So again, know that people are going to be uncomfortable about this, but it is your right. And finally, and Enrique, I'll make sure that I send this to you separately, and you can distribute it as you see fit. In addition to that Bazelon Center booklet, there are also a number of joint statements that have been made by the 2 federal agencies I mentioned earlier, the HUD and the Department of Justice Housing Section, that deal with reasonable accommodation, reasonable modification, group home issues in the community, and other things. I think one thing that's very powerful is that if the homeowners association tells you can't get what you want, walk in with a copy of HUD Department of Justice joint statement on reasonable accommodation and say, look here at paragraph 18, it tells me I'm entitled to this. If the federal government says I'm entitled, that must be pretty good evidence of it. So that's one other way, just as a without an advocate in your corner, that you can do self-advocacy. And then finally, as I said, the idea of trying to level the playing field by having your own advocate, whether it's from a nonprofit group or from a lawyer like me, I think it is a way to sort of keep the thing from escalating too far in the wrong direction, and help you sort of hold your head up high and insist on what you're entitled to.
Yeah, I think that last point is also like super important. So there's a lot of wisdom that needs to be exercised in these situations, from families, and it's difficult to navigate all these different things, to know exactly when to escalate what, but Michael, I mean, this has been fantastic, and we are really, really appreciative of your time, and we will be sharing the resources with our audience. But thank you so much for everything you do, and thank you for your support.
My pleasure. I will look forward to hearing from folks in your community.
Thank you so much.
Thank you.